Welcome back to the Friday Five for August 16th, 2024. My name is Andrew Ayers. I'm a business law and estate planning attorney with offices in Edina, Minnesota, and New York City. On Fridays, we like to take a quick 5-minute look at 5 questions, things that came up during the week, and try to answer them in about 5 minutes total. Question number 1 this week: is a self-made contract valid? So in this case, the caller had actually created a contract between themselves and another party, and it was actually relatively detailed for something that I see. Normally, I will see like a half page with just some random things on it and not really the form of a contract. But in this case, the two parties had actually taken the time to put together a contract that had different terms and almost looked like it had been drafted by an attorney, except it was a little bit short and didn't include some of the provisions we normally see. For example, there was an American Arbitration Association provision that was clearly taken from a different contract and didn't make sense for this particular contract. So we did a quick review of it, but in the end, it would have been a valid contract and will be if they end up signing it in its current form. When we have a contract, we want to make sure we look at the terms, we want to make sure that people are agreeing to it, and we want to go through the basics of a contract, whether we have consideration, meaning is something of value being exchanged, whether the parties are agreeing to it, whether the contract has been signed, and whether we have any questions about ambiguities or if it's pretty clear from the contract what the parties are agreeing to. So in this case, it did seem like the self-made contract is valid. But before you think your contract will be valid, it's important to go through the steps and make sure you've got all the important terms before you sign that contract that you drafted yourself. And if you've downloaded it from the web, make sure you understand where you got it from and whether or not it's relevant for the contract you are looking for. Question 2 this week: do real estate contracts have to be in writing? This was in a different caller this week, and we had a contract regarding real estate. And we're dealing here with an issue of what we call the statute of frauds, which is a legal concept that says certain types of contracts must be in writing. So you can agree to a lot of different things with people. You can agree to send your friend $5 for a Shake Shack burger that he paid for you for last week. You can agree to all kinds of other things. But when it comes to contracts like real estate, they're specifically required to be in writing. So in this case, although this party and his partner had decided to purchase real estate together, they needed to have the purchase agreement and the agreement between the two of them in writing because it was a real estate contract subject to the statute of frauds. So before you assume that that oral contract between you and somebody else is valid, make sure you speak to a professional and find out whether it should be in writing or not. Question 3 this week: do I need to sign a non-disclosure agreement? So as you're starting a business, and especially if you're working with another business and they're bringing you on to help, non-disclosure agreements are a very common document you'll run into. And the reason is that company that's bringing you on wants to make sure that anything they've created that's proprietary to them, it's their private information, things like client lists, things like inventions, they belong to the company and they don't want you having access to it and then just start spreading it around the world. Especially with client lists, you could easily sell it to somebody else. So what we do in those situations is use a non-disclosure agreement. And they're usually not particularly onerous. They're not very long. They're often 3 to 5 pages, and they will just set out the terms of, we're going to give you confidential information, and as part of that, you agree to keep it confidential, and after we're done working together, you agree to destroy it. Now, there'll be different items in each NDA, a non-disclosure agreement, but what you want to do is take a look at the terms and make sure you understand what are the requirements for you, what are you obligated to do once you've received that information. Question 4 this week: can my college-bound student get a will too, or just powers of attorney? So we're getting to back to school time, and I have a lot of clients bringing in their students who are getting ready to go off to college. And the common set of documents we're preparing for them are going to be a financial power of attorney, a healthcare directive, a living will, and a HIPAA authorization. And these documents are to allow their parents to have access to medical records and to help them with healthcare and financial decisions in case they become sick, because these students are all over the age of 18, so they're legally adults now, and the parents don't have an automatic right to make decisions for them. But with one of those clients this week, we talked about whether or not that student can also draw up a will. And the simple answer is yes, you can. Once you're 18, you can create a will. Now, you may not think you need one. You may think you don't have a lot of things, and so there's nothing to really divide up, but it still is a good idea to have estate plan documents in place when you're thinking about it. Now, most college first year and second year students are not going to be coming to my office to create a will. They want those powers of attorney, the healthcare directive. However, you can create a will for an 18-year-old, And it's a good idea. And if it's not at 18, maybe it's at 22 when they graduate college, just to have something in place to make sure that if something happens to you while you're young, we've got your assets taken care of. Question 5 this week: how can life insurance proceeds be paid before a will is probated? So this was an interesting case where a parent had died and they had a will, and the will has not been submitted to the court yet. However, the life insurance company reached out to the caller as well as their siblings, had them sign some documents, and sent them the life insurance payout. So the caller was confused because there hadn't been a probate yet and there hadn't been the will submitted to the court. We weren't even sure who was going to be in charge of the estate, and yet the children already got their money. Now, I didn't see the actual documents and we're not sure, but chances are what happened in this case is the life insurance policy had beneficiary designations on it, which means that that life insurance policy is distributed according to the beneficiary designation and is not dependent upon the will for how it will be distributed. This is also one of the biggest pebbles that I see people trip over. If you have a life insurance policy or if you have a retirement account and you don't name a beneficiary, then in that case, that money would go into your estate and would have to be distributed by your will, or if you don't have a will, to be distributed by your local probate court. That's why we plan for those assets by using beneficiary designations so that money can be transferred directly without waiting for the will. So in this particular case, the life insurance proceeds were likely distributed because it doesn't matter if the will was there or not, whether we're probating it or not, there's beneficiary designations, and this particular person left the money to their children and they get it directly by beneficiary. So that's it. That's our 5 questions for the week. If you like this video, you can hit the like or thumbs up button below. You can subscribe to future episodes on YouTube or go to ayerslaw.tv.com. There'll also be a link below for submitting a question for future episodes. And you can always go to andrewmayers.com to set up a legal strategy session where we can get your other questions answered. I hope you have a wonderful weekend.